All right, welcome back. We've got a fun one today. So, for those of you who are new here, I'm Joe. I'm an attorney licensed to practice in the state of Utah. Today's fun is British Columbia. It's Canada. It's different country, but the law is basically the same. So, it's it all descends from the British common law. So, that being said, we have a Canadian lawyer who has gone full Sovcit, which it's nuts. It has the potential to end her career in law, and it's terrible. It's absolutely terrible. But um, before I get to it, though, I should mention Ian Runkle very kindly sent me the documents. So I'm sure you're all familiar and all subscribed, but if you aren't, go subscribe. Runkle of the Bailey on YouTube. He's great. He's a Canadian criminal defense and firearms lawyer in Alberta, so next to British Columbia, and he does a really good job, which is obvious because he's got 100 times the subscribers I do. But yeah, so thank you, Ian. It's once again very kind of you. And so this isn't my first look at these documents. I did watch Ian's video, and it pretty much confirmed to me that, yeah, the law is essentially the same. And Ian also mentioned in his video that out of professional courtesy, he reached out to this lawyer to see if she had a comment. And she mentioned she's upset by the attention this has brought, the people contacting her. So I'm just going to reiterate. I I know I've said this before, but it needs to be reiterated sometimes. This is not a petting zoo. This is an animal safari. Keep your arms and legs inside the car. Don't contact people. This is for laughs on the internet, not to harass people. So just don't do it. Um, but yeah, so with all that out of the way, the basis of this sovereign citizen nonsense is the lawyer has sued her neighbor. The neighbor put up I believe a 5.5 foot privacy fence between their rooftop patios, gardens, whatever, and the sovereign citizen decided this has blocked my view. Therefore, she has trespassed. She has caused me damage. Therefore, I can sue. And not only can I sue, I can do so as a sovereign citizen. And she's wrong on all of it. Number one, putting up a fence, as long as it's within the local ordinances, putting up a fence is fine. And if it blocks the neighbor's view, it blocks the neighbor's view. It doesn't matter. It sucks, but it doesn't matter. I mean, from my house, looking about right that way, I would have an absolutely amazing view of Mount Olympus here in the Salt Lake Valley. But trees block it. Should I sue my neighbors to cut down their trees so I can see Mount Olympus? No, because I do not have a property right in a view of Mount Olympus, as beautiful as it is. Now, if I if I drive to the elementary school 2 blocks down the road, I have a completely unobstructed, marvelous view of Mount Olympus. So, frankly, if I get on the road and, just drive anywhere, I have that view. But from my house, I have views of the mountains, not of Mount Olympus. But it, I can't, I don't have a cause of action against anyone. Of course, I like trees, so I wouldn't anyway. But, um, so yeah. I think let's go through the documents that have been filed, and then we will discuss some legal concepts. We'll take a look at spite fences, which, frankly, this isn't a spite fence, but we'll look at the law on when a fence goes too far, and that's a spite fence, and even a spite house is a thing. Um, and then we'll look at a few things that aren't exactly spite fences, but they're in the same ballpark. And I realize I forgot to Google my favorite one, but we'll pull that up when we need to. Um, and then we'll need to also discuss the common law tort of nuisance and the common law tort of trespass. There's three common law trespass doctrines. There's trespass to property, which I assume that's what this sovereign citizen is claiming under. But once again, she doesn't have a property right in the view, at least not necessarily. There's trespass to the person, which to me is fairly redundant because that's generally going to be subsumed into like assault battery type causes of action. And then there's trespass to chattels. So once again, that's most of the time going to be theft or something like that. Or although, technically I ram my car into your car, that's going to be a trespass to chattel because you own the car, it's your chattel. Um, but once again, to me, most of those, other than trespass to property, is fairly archaic because there's newer and more specific torts. So at least that's my opinion. So let's get into the documents. This is the notice of civil claim in the Supreme Court of British Columbia, which I assume, like I said, I'm a Utah-based lawyer. I'm assuming this is the equivalent of the Superior Court, or like in New York State, the Supreme Court is the main trial level court. So I'm assuming that's what this is. I could be wrong. Like I said, I'm a Utah-based attorney. This would be brought in the district court here, at least for the amount if I remember right, for the amount. Well, and especially since she's asking for injunctive relief, so it would have to be in the district court because our municipal courts are the um at the civil, it would be the small claims. So but even if she's below the small claims limit, since she's asking for injunctive relief, it would have to be in the district court. So never mind. But so in the Supreme Court of British Columbia, between the woman, Naomi Arbabi, and that's all in lowercase. So what does this tell me? This tells me she's buying into some of the US based sovereign citizen nonsense because number one, it's all lowercase. And for some reason, sovereign citizens think that matters. But also, it to some extent, she's following the grammatical nonsense of the postal court, parse syntax grammar of the Russell J. Gould and his predecessor, uh, the Supreme, the Chief Justice of the Supreme Postal Court, that flavor of sovereign citizens, where everything is, all about punctuation and nonsense. And so but they don't have any hyphens, so just colon. But either way, so between the woman, Naomi Arbabi, plaintiff, and the woman, Colleen McClelland, defendant, notice of civil claim. Rule 22-3 of the Supreme Court Civil Rules applies to all forms. This action has been started by the plaintiffs for the relief set out in Part 2 below. If you intend to respond to this action, you or your lawyer must A. File a response to civil claim in Form 2 in the above named registry of this court within the time for response to civil claim described below, and serve a copy of the filed response to your civil claim on the plaintiff. So this looks like it's the stock form provided by the court, which many courts do, and they basically serve as a template to put together a complaint. And or it could simply be the cover sheet. We've in fact, we've looked at the federal rules of civil procedure many times on this, and we've looked at Rule 4 before. And once again, I know this is U.S. federal rules of civil procedure, and we're talking about a case in Canada. But I'm doing this as a comparison. So we have seen, like I said, Rule 4 is the summons, how to initiate the lawsuit. And so we have seen this notice of lawsuit and request to waive service of summons to to defendant. Why are you getting this? A lawsuit has been filed against you or the entity you represent. In this court, under the number shown above, a copy of the complaint is attached. This is not a summons or an official notice from the court. It is a request. So blah blah blah. So basically, that's what this form looks like to me, is the British Columbian version of the notice for a summons, standard form. But we'll continue reading it anyway and just get into the whole thing. So, if you intend to make a counterclaim, you or your lawyer must A. File a response to civil claim in Form 2 and a counterclaim in Form 3 in the above named registry of this court within the time for response to civil claim described below, and B. Serve a copy of the filed response to civil claim and counterclaim on the plaintiff and on any new parties named in the counterclaim. Judgment may be pronounced against you if you fail to file the response to civil claim within the time for response to civil claim described below. Time for response to civil claim. A response to civil claim must be filed and served on the plaintiffs A. If you were served with notice of civil claim anywhere in Canada within 21 days after that service. So that's the same time frame as provided in the Federal Rules of Civil Procedure. B. If you were served with the notice of civil claim anywhere in the United States of America within 35 days after that service. If you were served with the notice of civil claim anywhere else within 49 days after that service, or if the time for response to civil claim has been set by order of the court within that time. So, funny enough, let's see. I think I clicked the wrong one. It's been a while since. I think it's in Rule 12. So, yeah, I knew it was Rule 12. But in general, a defendant must serve an answer within 21 days after being served with the summons and complaint, or if they've timely waived service under Rule 4D, so the request for waiver of service, they get 60 days, or within 90 days after it was sent to the defendant outside of any judicial district within the United States. So basically, Canada has the same, at least British Columbia has the same general 21-day period as the federal rules of civil procedure, but the federal rules are more generous with international defendants because they give 90 days, and that includes Canada, whereas Canada only gives 35 days if it's a US resident and 49 days anywhere else. So that's interesting. So now we get into the actual meat and potatoes of the complaint. And like I said, I haven't redacted anything because if you act a fool and put nonsense out into the world, it's not up to other people to protect you, is my opinion. And you file with the court, it's a public record. So I don't redact, but I also don't read addresses or phone numbers or anything of private people. So once again, I haven't redacted, but do not, and I mean do not, contact her, do not harass her, do not leave bad Google reviews, do not do anything. If you want to do anything, do it in the comment section of my video within the terms of service, of course. And I should mention, though, she is a lawyer in British Columbia. But what kind of lawyer is she? That's important. That's very important. She's a real estate lawyer. She's a real estate lawyer. So she should really know better than to do this crap, because this would be the kind of thing you'd hire a real estate lawyer for. So that makes it even worse. Like, you hire me to do a divorce, you may as well hire the plumber down the street. I don't do family law. I don't know family law. It's gobbledygook to me. I could learn it. I'm technically licensed to do it, but I could mess it up really bad. Hire me to do criminal defense, and I'll do a pretty good job, I hope. With her, she should know better, especially within real estate, within trespass. This makes it worse. But claim of the plaintiff. Part 1. Statement of facts. I, a woman, claim I believe the property of I is what is proper to I, and it's lowercase I, exclusive of all others within the society, and I claim the apartment in Vancouver, British Columbia, including but not limited to all its aesthetic appeals in form of its breathtaking views of the ocean, the mountains, the bridges, Stanley Park, and more as the property of I. So basically, she's saying, this view is my property. That's not how it works. If that were how it worked, I'd go stick my flag on Mount Olympus about 3 miles that way, and I'd say, this is my property. I have claimed it as my property, and I shall tax everyone who gazes upon its beauty because it is my property. But that's ridiculous. It's preposterous. It's asinine. It does not work that way. And like, unless there's a deed restriction or something that limits the defendant's right to build this fence, or an ordinance or a law, there is no such property right. Now, let's say I have a pretty big backyard here. If I were to subdivide that backyard, but I want to keep the view I have, I could, in theory, put a deed restriction on the part of the backyard I sold. And I could say, this part of the yard cannot be built on in order to preserve my view, and put that as a restriction on the deed when I sell it. Now, presuming it doesn't run afoul of local law, that's binding on not only on the purchaser of the property, but on every subsequent purchaser of the property. You might say it's like a view easement. But unless that has been done, and it has to be done when I subdivide the property for me, or I could pay, like, my brother lives next door. If I wanted to preserve my view that way, I could pay my brother for an easement, a view easement. But in order for it to be valid, I'd have to provide some sort of consideration for it to be a valid contract. And unless this lawyer has done so, she has no valid property right in any view. Now, I think this is a good time, though, to discuss London. Like I said, all of this goes back to the English common law. Whether it's now based on statute or still common law, it's based on the English common law. But London is an interesting city. Although the city of London itself is tiny, like 500,000 people, I think, 1 square mile. So I'm talking Greater London. So Greater London has what are I'm going off of memory here, but they're they're protected view corridors, and I believe there are 7 of them. And it's basically by law, there are protected views saying from this location, nothing can be built blocking view of this distant location. So, like, it might be from Hampstead Heath, you have to be able to see into, see the Battersea Power Station. I'm just making up, North London to the river. It's a protected view. You can't build anything so tall that it blocks it. But that's by law. But that this lawyer is basically trying to implement that personally for herself based on nothing. So I claim that a woman, Colleen McClelland, after being noticed, does knowingly trespass on I. I feel like Bob Marley should be singing this. I claim the trespass comes by way of loss of enjoyment and loss of value of the said property of I, and administrating the property of I without right or consent, and these trespasses do and does cost financial loss, loss of property, enjoyment, and stress. I claim to have full vested interest in said property since July of the year 2021. I claim that commencement of the trespass began on September 5th, 2023, at approximately 10 a.m., when the woman, Colleen McClelland, caused to be installed a 66 and 1/2 inch tall privacy wall at the border of her part of the rooftop deck, which is shared with I and 2 other neighbors, thereby blocking the view of the ocean, mountains, Stanley Park, bridges, and more from the property of I. So 66.5 inches, that's 5 feet. Now, once again, this is Vancouver, British Columbia, Canada. I live in the state of Utah, in Salt Lake City. So here in Salt Lake City, the general height allowed for fences is set by ordinance, by city ordinance. And it's I didn't look it up. It's been a while since I've seen it, but depending on location, it's generally either 6 feet or 8 feet tall. Now, that's for a fence on the ground between yards. Now, if there's a purpose for it, a fence can be much higher. Like down the street, I mentioned the school from which you have an absolutely phenomenal view of Mount Olympus. Now, that school has 2 baseball diamonds, and the backstop, the fence is 25, 30 feet high. Now, that's not separating one property from another, but it's a much higher fence. In fact, the entire school ground, um, it the front of the school is on a busy road, but all 3 other sides of the schoolyard is surrounded by residential property. The fence is 15, 20 feet high. Now, that generally wouldn't be allowed, but there's an exception in the ordinance that has allowed it. And it makes sense. The purpose is, hey, this is a schoolyard. There's children here. We need to keep people out. We need to keep the children in. We need, there's balls flying around at recess, and we need to keep them in from going into other people's yards. I remember when I was a kid, we played soccer right next to that fence, and it was a real pain the on the occasions the ball went over that fence. So luckily it went into an apartment rather than a single family home's backyard, so the apartment was a lot easier to get to. But generally though, the now there could be an ordinance saying on a rooftop deck, this is what you're allowed. But it also might be, once again, within the homeowners association, uh, an agreement within the building. Privacy fences are limited to this height. It could be down to the total building height. That could limit it. But 66.5 inches, 5.5 feet is reasonable for a privacy fence. And like, even if it's a spite fence, which it's not, 5.5 feet is reasonable, even if it's just put up to piss off this woman. It's still reasonable. But we'll, like I said, we'll discuss spite fences in a bit. So, I claim the trespass continues to this day, October 5th, 2023. I claim, after being noticed and requested by I to have a discussion to find a solution whereby both our concerns with regards to our properties can be resolved. The woman, Colleen McClelland, did not provide remedy and instead demonstrated her intent to resort to threats, extortion, and barratry against I. Barratry is an old common law tort and even crime, which basically amounts to abusive litigation. Barratry is no longer a thing in many jurisdictions. I can't speak for British Columbia, but either way, it's she's saying, hey, the defendant, I tried to be reasonable and deal with the defendant outside of court, but she didn't want to provide remedy. Guess what? You don't have to compromise with nut jobs. You don't have, like, if you build a legal fence and the neighbor doesn't like it, you don't have to compromise. You can say and be done with it. Now, I mentioned we have a big yard back there, and I meant to take a tape measure and measure it, but measure the fence between our backyard and the neighbor around the corner. Our backyard goes to the side of theirs. So it's board fence. It's, wood pickets, no space between them. But then above there's a crossbar 2x4 on top, and then a decorative lattice with another board on top, which adds a foot. So I think the fence itself goes 6 feet, but then there's that extra 7 or extra foot, bringing it to about 7 feet. So, like I said, this I think the ordinance is either 6 or 8 feet here. I can't remember. I don't care. That fence predates us owning that yard. It was built by previous owners. In fact, I think it was built by previous owners of the neighbor's yard. But either way, it's an old fence. We've repaired it, but it's an old fence. The thing is, it's not visible to anyone but us and my brother, because it also separates some of his yard from theirs. But if we decided we didn't like our neighbors and we wanted the fence brought right down to the line, well, first of all, they'd have the argument, hey, this is grandfathered in. You've never complained. It's been here for 40, 50 years. You've never complained. Therefore, you can't force us to take it down now. It's grandfathered in. But we, the rest of the fence, though, we wouldn't have any legal basis. Like, they wouldn't have to compromise with us at all. They wouldn't have to provide remedy. And there's a bit of a hill in the backyard. The fence goes along and then it goes, so it's not completely level across the top, because even between neighbors who like the fence, it has to follow the contour a bit. But yeah. So, part 2, relief sought. That said, I now require compensation as per the notice sent to the woman, Colleen McClelland, on September 28th, 2023, which totals $30,000 for the 30 days as of the date of this notice since the trespass started, plus $1,000 per every additional day until trespass has been remedied in court, plus administrative cost for the notices of $4,200 as of the date of this notice, plus court fees and other expenses. Alternatively, I may accept at the sole discretion of I anything of equal value which may be offered as compensation. So this basically reads to me as a sovereign citizen fee schedule, which, once again, is nonsense. It's based on nothing. It's I remember the word today because someone put it in my comments again kindly when I couldn't remember it the other day. It's Borogrove. It's Jabberwocky. It's nonsense. Ooh, this part should be fun. Legal basis. This is a claim of trespass by way of loss as pressed by a woman, Naomi Arbabi, against a woman, Colleen McClelland. This is a claim based on law of the land and not a complaint based on legal codes, acts, or statutes. A claim of trespass by way of loss did arise when, after many attempts to keep this matter private and resolve the dispute peacefully in a manner that preserves the rights of both sides to the use and enjoyment and administration of their own property, the woman, Colleen McClelland, did not provide remedy or a lawful excuse. Which, once again, she didn't have to. All she had to do is say, this fence is legal. Kick rocks. She doesn't have to provide a lawful excuse. The lawful excuse is it's a privacy fence. A privacy fence is reasonable. It's legal. It's not a trespass. You have I mean, she says the defendant hasn't provided a remedy or a lawful excuse, but you get to just make shit up. You get to say, I have a property right in the view, even if you don't. Which, once again, unless it's in your deed when you bought the property, and or a restriction on her deed when she bought the property, it doesn't exist. It never existed, and it will never exist. Your remedy, if you want that view, is to buy the property from your neighbor and take down the fence. Extend your property. That's your remedy. I did acquire my property at a time when a much lower, clear glass divider that was installed previous to this 66 and 1/2 inch wall allowed the addition of the aesthetic appeals of the said views to the property of and I did rely on views in making the decision to purchase the property of and in negotiating a purchase price for the property of I. You know what it sounds like to me? It sounds like to me before I, sovereign citizen, purchased this property, the defendant was happy with the shorter, transparent divider. I imagine the sovereign citizen, is a nightmare to live next to. I'm guessing that's why the larger, non transparent wall was put up to give the defendant, separation from the sovereign citizen. I did conduct due diligence searches to inquire about the conditions of the property of and the neighboring properties, and did not find any evidence of the woman, Colleen McClelland, having the rights to block the view of other properties behind her property. But did you search for deed restrictions? Did you search for something preventing her from doing it? Because that's what matters here. She would generally have the right to put up the privacy fence around her property. That's the rule, is you have the right. Unless there's something saying you do not. Unless there's a homeowners association that says this is the kind of separation you can have on your rooftop balcony, or an ordinance, a deed restriction. You searched for the wrong thing. Great real estate lawyer here. Therefore, the woman, Colleen McClelland, is estopped from asserting a right to install such a wall on her property that will block the view from the property of I say herein and verify in open court all to be true. And skip over the addresses and phone numbers and signature of Naomi Arbabi, a woman. And Rule 7-1 of the Supreme Court Civil Rules states, 1. Unless all parties of record consent or the court otherwise orders, each party of record to an action must, within 35 days after the end of the pleading period, A. Prepare a list of documents in Form 22 that lists 1. All documents that are or have been in the party's possession or control, and that could, if available, be used by any party at trial to prove or disprove a material fact. And 2. All other documents to which the party intends to refer at trial and serve the list on all parties of record. And we have an appendix. The Part 1, concise summary of nature of claim. Claim of trespass by way of loss pressed by a woman against a woman. This claim arises from the following: a dispute concerning not a motor vehicle accident, not medical malpractice, but another cause. A personal injury arising out of a matter not listed here. This claim involves not a class action, not maritime law, maybe. I let's just say I would laugh if the sovereign citizen had selected maritime law here, because that would have been hilarious. I mean, it involves view of the ocean, doesn't it? So maybe that is maritime law, except not really, never, doesn't work. Nothing in enactments. Notice of requirement of court. October 5th, 2023. Greetings to the man or the woman who at times acts as the clerk of the court. I am grateful for your time, your attention, and your services. I, a woman, Naomi R. Bobby, say at a time when those of mankind trespass on the rights of I, and in doing so, instead of providing remedy, they knowingly hide behind the complexities of the legal system. It is time for I to come forward as a woman, present in honor, to seek remedy by opening a case to press this claim of trespass against those of mankind I believe to have done trespass to I. This looks to me like the standard sovereign citizen. We've seen it before in other sovereign citizen cases where they basically present the law of the case and they make shit up and say this is the law, and you have to judge, you have to make your decision based on this law that I made up and sent to you and isn't actually law. um well and I'm trying to it it shows up a lot in Moorish sovereign citizen cases. I I know we've seen it before in previous videos of mine. I can't remember what video it was. And I'm scrolling through my YouTube videos. I'm thinking it's either the Rayland Brunson nonsense from here in Utah, the wackadoo that sued based on the Book of Mormon to overturn the presidential election. I've been meaning to check in on that one because it's nuts. Oh, it could be looking at Chase Allen's mother's documents, the sovereign citizen who was shot by police here in Utah earlier this year. Could be his mother. Could be the former NBA player that went more. So it's in one of those, I think, that we saw the law of the case, even though it's at best a misstatement of the law, at worst, completely made up. I say, after many attempts to keep this private and to operate as a woman with rights, no remedy has been given, and instead, only more wrongs have been committed by way of threats, extortion, and barratry, which, if carried out, I say amount to abuse of the legal system. Pot, meat, kettle, and abusive abuse of the legal system. This has led I to now require a court of record to press a claim of trespass and to present I before a man or woman who is competent of property and trespass law there to keep the peace and put forward the orders of Naomi Arbabi court. So the gall of this bitch to she wants the court to put forward the orders of her. Not I request the court for relief. I require this court to enforce my orders. That is insane. The like even aside from it being so legally fanciful and delusional, it's the arrogance. The main person, the main character syndrome. It's insane. It's offensive. I wish to press this claim on a woman I believe knowingly continues to trespass on the rights of I, and whom I have noticed of this trespass. And you may notice I speak a little funny. It's because her punctuation, her grammar is funny. Because it's I, comma, wish to press this claim on a woman I, comma, believe knowingly continues to trespass on the rights of I, comma, and whom I, comma, have noticed of this trespass. So I've been emphasizing that comma. And there hasn't been a single damn period here. Or I guess this is Canada, so it would be a full stop. I believe Canada uses the full stop like England. But either way, not a single one. This is all like each of these paragraphs is separated by a semicolon. It's nuts. For the sake of clarity, I will not be appearing or representing as a member of the Bar Association or under any surname or as a civilian. And I will not diminish the status of I to any legal titles such as, but not limited to, lawyer, pro se, complainant, plaintiff, or claimant. Well, I've got news for you, sunshine. You are a lawyer. Therefore, even appearing pro se, which you are, even if you don't claim the title of pro se, you are self represented, but you are still a lawyer. Therefore, you are still held to the standards of a lawyer. You also have the same privileges as a lawyer. So you get to file in court. You get to e-file. You don't have to request permissions that you already have as a lawyer. But you don't get to just say, hey, for the purposes of this, I'm not a lawyer, therefore you can't hold me to the standard of a lawyer. That can't work that way, because you are a lawyer. You should know better. And frankly, as a lawyer, you can't say, well, in this case, I'm not appearing as a lawyer. I'm just appearing as a woman. Therefore, if I bring a frivolous claim, a patently frivolous claim that is otherwise sanctionable, if I behave in a manner that is sanctionable, even worthy of disbarment, you can't hold me to that. I'm appearing as a woman, and a woman can't be disbarred. I can't be removed from the Bar Society, the Bar Association, whatever, of British Columbia. You can't punish me. I am merely a woman. The problem is, she is a lawyer, and her license is on the line. We'll see if she keeps her license. We'll see how badly she is punished. Like, because even if she has a claim here, the way she's going about it would still get her sanctioned. This sovereign citizen nonsense will get you sanctioned. Although I guess it's Canada, so it's OPCA or OCPA, whatever. What no, Chief Justice Rook. I was going to say Rook versus Rook, but it's Meads versus Meads. So Chief Justice, former Chief Justice now of the Alberta King's Bench, Justice Rook, declared it OCPA or OPCA, OPCA, or organized pseudo-legal claims and something or other. Either way, Justice Rook named it that in Meads versus Meads, and that has stuck in Canada. I will be present simply as a woman to press a claim of trespass. I simply require a room to move this case through the court, and I choose to be present before a court of record under oath, there to testify with facts to support claim of trespass. I require no legal advice and no legal forms, as I am not present as a member of the Bar Association, and this is a claim, not a complaint. That said, in order to move this claim through the Naomi Arbabi court in a timely manner, I may agree in good faith to use your forms with variations noted within the forms or as described in a notice such as this or other attachments to fit the circumstances of this claim. But this should not be construed by any man or woman as the submission of I to any legal titles, legal codes, acts, or statutes. So apparently, everyone is subject to the Naomi Arbabi court. She gets to make claims in the Naomi Arbabi court, and she gets to demand the court of British Columbia, the Supreme Court of British Columbia, enforce her demand based on the claim in the Naomi Arbabi court. Do I need to start the Joe court? Are any of you going to give any notice, any weight to the rulings that come out of the Joe court? I didn't think so. I say herein and verify in open court all to be true, Naomi Arbabi, a woman. Oh, rules of the court. Who needs the rules of civil procedure? Who needs the local rules? Naomi Arbabi has her own rules, ratified by her, enforced by her. We all get to follow them. So says her. I, a woman, Naomi Arbabi, will be present to press a claim of trespass under oath at the Naomi Arbabi court on the date scheduled by the court of the clerk at the Court of British Columbia Supreme Court. I require the man who at times acts as judge or magistrate to give his oath to the following at the Naomi Arbabi court. I, judge, give oath that I will be true to serve those of mankind in the office of judge or magistrate, and will do right by all manner of mankind, and uphold the law, there to witness a claim with facts, to support said claim, and to render a verdict without fear, favor, affection, or ill will. So help I, God. So apparently, when sovereign citizens ask judges, are you honoring your oath today? Have you put your oath on the record? This bitch wants them to take an oath to her. They want them to take her oath. This is a whole new level of delusion. The main character syndrome, this is nuts. And it's not, she requires the judge to take this oath. I've got news for you. The judge isn't taking your oath. The judge was sworn in by a legal process. I don't know what it is in Canada. I don't know what the oath is in Canada, but I'm sure it was an oath to the king, probably the queen, when the judge became a judge, because there hasn't been a king for very long. But an oath to the king and Constitution and people of Canada, blah blah blah. In fact, I bet we can look it up. Here we go. Oath of office. Every judge shall, before entering on the duties of the office of judge, take an oath in the following form. I, judge, do solemnly and sincerely promise and swear that I will duly and faithfully, and to the best of my skill and knowledge, execute the powers and trusts reposed in me as Chief Justice, or as one of the judges, of the Supreme Court of Canada, so help me God. So, apparently, that oath isn't good enough. This judge has to take the Naomi Arbabi court oath. I require a court of record for the Naomi R. Bobby Court at the Court of British Columbia Supreme Court. I require every man and woman summoned to give oath to testify to what is true under penalty of perjury. This court will not accept any legal arguments, codes, acts, or statutes, as this is a court in law based on the law of the land, and therefore a presumption of contract does not apply to I. So it's you know how I've quoted former Representative Dingell from Michigan many times on procedure, and once again, I'm going to mangle the quote, but it's basically, you know, you can have the facts as long as I set the procedure, I'm going to win the argument. I'm going to win. That's what she's trying to do. But she's not just trying to set procedure. She's trying to state what law applies. How can you lose if you declare what the law is and what the procedure is in addition to what the facts are? I mean, why even show up to court if the defendant, you know, is powerless? She can't state, I have the legal right under such and such section of the, you know, Vancouver ordinances to enact a privacy fence. Well, that's a law. You can't use that. This is my law, and I get to declare what it is. What's the point of court if one party gets to decide what the law is? I mean, does the defendant get to bring her own law in her answer to the complaint? And then have mediation on what the law is, the agreed upon law, and then decide who wins based on the mediated law? No, you go off of the law that has been enacted by the city government of Vancouver, the British Columbia provincial, you know, legislature, whatever it's called. You know, the Canadian federal legislature. There's a reason we go off of the actual law instead of negotiating the law as we go along, as to each dispute. Now, you can negotiate the result. You can negotiate to have the defendant lower the wall to 4.5 feet from 5.5 feet to allow for a view, but that would be negotiating the result, not negotiating the law. And certainly one side doesn't get to dictate this. I say this is the law, therefore you have to follow it. You're not a dictator. If you want to be a dictator, seize power. I mean, don't do it, but that's the way to do it. This court will only accept claims with facts and evidence to support any and all claims. This court is to be private. Not quite. It's gone worldwide. I say if the woman summoned for trespass does not have a lawful excuse for the trespass or claims to the contrary, and the man or woman acting as magistrate or the jury has the findings of facts and conclusions of law on the record to make a verdict in favor of I, the woman whom now presses this claim, then the orders of the Naomi R. Bobby Court are to be enforced, and orders presented before said court to be tendered to the clerk of the court with the final verdict. The orders binding bear the court seal of the Court of British Columbia Supreme Court upon it, and is to be carried out in 21 days of the verdict. I say, if the men or woman of or clerk of the court believes it is not possible to proceed in this lawful manner, then the Naomi R. Bobby Court requires their findings of facts and conclusions of law on the record to prevent trespass on a case. I say all herein to be true, and will verify at open court. Naomi R. Bobby, a woman. So basically, she's saying, hey, you have to agree to my rules. And if you don't, you, court, have to put in writing why I am wrong. No, the court doesn't have to. The court doesn't have to answer your questions, period. They have to rule on your motions eventually after the other side is given a chance to respond, due process. But they don't have to respond to your questions. They can tell you to pound sand. That's just how it works. And so, moving forward, we have a notice of application from the defendant. And someone, after this was printed out, hand wrote the woman, before both Naomi R. Bobby and Colleen McClelland. It very well could be Colleen McClelland is, at least at this point, self-represented. And her self-represented documents make a lot more sense and are way more legally sound than the lawyer, the woman, Naomi R. Bobby. But being self-represented and not a lawyer, she may not have realized that the woman, between the woman, Naomi R. Bobby, and the woman, Colleen McClelland, was not a legal requirement, not a legal style requirement. She wouldn't have known that it's sovereign citizen Jabberwocky gobbledygook nonsense. It's Borough. See, I remembered again. So she may have thought this was a legal requirement, but it also might have been, let's go back. The case is styled as the woman, Naomi R. Bobby. So this could have actually been the court clerk writing it in so that it matches up with the case caption for the case. So I'm not sure exactly who put it in and why, but there could be an administrative reason. There could be a misunderstanding of law reason from the defendant. So, notice of application. Names of applicants, Colleen McClelland, to Naomi R. Bobby, plaintiffs. Take notice that an action will be made by the applicants to the presiding judge or master at the courthouse in Vancouver, British Columbia on November 29th, 2023 at 9:45 a.m. for the orders set out in Part 1 below. Orders sought. 1. An order striking all of the plaintiff's claim, which frankly should be granted because in the U.S., if this were in U.S. federal court, this would be 12b6 because there is no claim stated upon which relief can be granted. Yeah, she says trespass, but she just conclusorily states that she has a property right in the view without something backing up that claim. That's just a conclusory statement, and that doesn't suffice. Now, I can't say that's the standard in Canadian courts, but here it is. And frankly, this is so bad, so frivolous, that a motion to strike might even be granted in U.S. federal court, not just a 12b6, but a motion to strike, because it's so patently frivolous that the judge should just say, yeah, this has never existed, basically. So she's seeking an order striking the plaintiff's claim, such further or other relief that this honorable court may deem appropriate, full indemnity costs on this application payable forthwith, and a court referral of complaint to the Law Society of British Columbia. So she's asking the court to forward this to the Law Society to punish this lawyer, this sovereign citizen. Part of her relief she is asking the court for, the defendant, is to refer this to the Law Society, to the bar, to punish, to disbar, to fine at the very least, to assign her to a legal mentor, to check her filings, something, because clearly she is not fit for the practice of law. Factual basis. This motion to strike application concerns a privacy divider that was reinstalled by Strata Corporation, Strata Plan VR 1542, represented by Strata Council, Strata, on September 5th, 2023. So, I'm curious. So, being American, being from the US, being in Utah, had to Google. I just did it on my phone. What is a strata in Canada? Strata housing is often referred to as condos or condominiums. However, strata housing not only includes apartment-style condominiums, but can also include duplexes, townhouses, fractional vacation properties, even single-family homes in bare land strata corporations, strata subdivisions. So basically, what part one of the factual basis says, this clears it up for U.S. viewers. This motion to strike application concerns a privacy divider that was reinstalled by the Strata Corporation Strata Plan, by the Condo Association, the Condo Corporation, represented by council, Strata Council, by. So basically, the defendant is saying, look, it was, at least based on this, my reading is, look, I didn't even install this privacy wall. It was the HOA. The condo association installed this. In which case, not only is it allowed, it was imposed. They put it there. The privacy divider was reinstalled. So it was there before by strata, by condo on the limited common property LCP of the applicant, Colleen McClelland, owner of strata unit blank. The original divider was removed and disposed of by the owner of strata next door without strata approval. This owner's strata lot borders the LCP, limited common property, of Colleen McClelland's, but he is not a party to this litigation. So this isn't even the privacy wall between the plaintiff and defendant. It's between the defendant and the other neighbor, from my reading. Wow. And it was removed by the owner of the other unit. So if it's on the property line, and especially since presumably it was built by the condo developer, by the strata builder, so it's an original feature by the sound of it, and so it would be the property dividing line. And in that case, one person can't unilaterally remove it. You have to have both sides. So Ms. McClelland or the Strata Corporation could have sued that neighbor to reinstall it for the fees, for the costs to reinstall it as an original feature, because he didn't have permission either from the strata or her to remove it. And like, did Naomi, our Bobby woman, when she moved in, did she notice the same 5.5-foot wall between every single limited common property except this one, and say, well, if they put a matching 5.5-foot wall there, they're trespassing on me? And if every single other border between limited common property had that same wall, did she not realize that maybe that one should have one, and it could in the future, and not seeing anything limiting them from reinstalling it or installing it or whatever? She declared a property right in the view unilaterally. I'm getting sarcastic because this is insane. By removing the divider, the owner of the other unit made significant changes to the limited common property of both strata lots that were not authorized by strata. Accordingly, the changes were not taken to a vote by the other owners or registered with the Land Titles Office. So, like I said, the HOA equivalent didn't vote that it could even be taken down. So the HOA has probably required that it stay up without a vote to take it down. The respondent, Naomi R. Bobby, is the owner of that lot. So yeah, the defendant appears to be in the middle between the Naomi Arbabi and the neighbor that took the wall down. So she's caught in the middle between two people who think they have rights that they don't. Lucky her. So the respondent, Naomi Arbabi, is the owner of one lot whose limited property, limited common property borders the owner of another lot. Naomi Arbabi's lot does not border Colleen McClellan's. Oh, so sorry, I got that wrong. It's Naomi Arbabi, the neighbor who took the wall down, and then the defendant. So the neighbor who took the wall down is in the middle. Okay. Strata wrote to Naomi Arbabi on September 5th, 2023. The document was incorrectly dated February 5th, 2023, and stated that it was abiding by the letter of the Strata Act as advised by counsel in first replacing the divider and then ensuring that the owners of the units understood there was a Strata Act procedure to replace the original with an alternative. Colleen McClelland is not a member of the Strata Council. Legal basis. Rule 9-5, striking pleadings, scandalous, frivolous, or vexatious matters. At any stage of a proceeding, the court may order to be struck out or amended the whole or any part of a pleading, petition, or other document on the ground that A, it discloses no reasonable claim or defense, as the case may be. B, it is unnecessary, scandalous, frivolous, or vexatious, or skipping C. D, it is otherwise an abuse of the process of the court. 2. The Strata Property Act, SBC 1998, Chapter 43. S171 Strata Corporation may sue as a representative of all owners. Section 172, Strata Corporation may sue on behalf of some owners. To the extent that ground for relief may be arguable, it must be put forward by the Strata Corporation, who is authorized by Section 171 of the Strata Property Act to sue as representative of all owners except any who are being sued, if authorized by a resolution passed by a 3/4 vote of those owners who are not being sued. The wrong alleged is to the Strata Corporation. Thus, only that corporation may seek relief. Foss versus Harbottle. I don't know what court that is because I don't know Canadian citations, but it's Foss versus Harbottle from 1843. And Extra Gift Exchange Inc. versus Collins. That's going to be British Columbia Court of Appeals, 2004. So that's huge. That is absolutely huge. So basically, to summarize that, it's Naomi Arbabi, woman, doesn't have a private cause of action here. Like, even if the wall were wrongfully put up, she does not have a cause of action against the neighbor who did it. But it wasn't even the neighbor who did it. It was the Strata Corporation. But if she wanted to sue, she would have, like, if she thought it was wrongly put up, she would have to go to the Strata Corporation to have a 3/4 vote of those not committing a wrong against her, and if 3/4 vote, the strata corporation itself would have to be the plaintiff to sue to get the wall taken down. So her basically her options here, I mean, in theory, I guess she could sue the strata corporation, but once again, under what cause of action? Because she never did have that property right. But her other option would be run for the council and or put it up for a vote of the association to take down the walls. That's your remedy. Not suing a neighbor who the wall separates her property from another, but she didn't even do it. But even if she did, as long as it's allowed by the strata corporation, it's fine. So, in this regard, I agree with the reasons expressed by Judge Lurie in Eng versus Spectra Management Services Limited, uh, Brit 2002, British Columbia Supreme Court, blah, 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 particularly in paragraph 17, where he wrote that an owner should not be permitted to circumvent the governance provisions of the Act and achieve what it cannot achieve through a special meeting of the owners. I'm assuming that is from Extra Gift Exchange versus Collins. And to the extent the dispute involves the use of common property, including limited common property, the proper party to enforce the interests of the individual owners must be the strata. And that's Chikes versus BM Clubhouse, British Columbia Supreme Court, 2023. And substantial indemnity costs awarded to defendants in a claim that made pseudo-legal arguments, and that's Sekalovsky versus Arkin, Ontario Supreme Court, 2021, and Civil Resolution Tribunal Act, Chapter 25, Part 10, Division 4 of the CRTA. CRT has jurisdiction over strata property claims. So basically, she's saying, look, I can be paid damages for this pseudo-legal nonsense, and you can't bring a private cause of action to circumvent the governance provisions of the Strata Act or the Strata Agreement. You have to follow the rules. You can't just sue. So let's go back to the federal rules of civil procedure, because, like I said, the substantive law is largely the same, at least as far as trespass and nuisance and that stuff. Condo laws, strata laws, those can vary wildly from city to city, not just country to country. But the procedural rules, let's look at Rule 12 again. So the defendant in this case, if this were brought in the US but under the same strata laws, would in essence file it would be a 12b6 because you haven't stated a claim which relief can be granted, because the defendant can't provide that relief because only the strata corporation can. So I would also file a 12B7 failure to join a party under Rule 19, although that's kind of not quite right because it's not, this isn't a failure to join. It's a, you sued the wrong person, dummy. And so I mean, in theory, well, frankly, the motion to strike should be granted. If it isn't, and it isn't dismissed, the Strata Corporation basically should intervene. It should say, and I like I said, I'm basing this off of U.S. procedural law. I'm not gonna look up if Canada has intervention, but basically, intervention, if you remember, we have discussed the Hollingsworth versus Perry, or other way around, which was originally, I think, Perry versus Schwarzenegger, or Perry versus, or Hollingsworth versus Hollingberry versus Schwarzenegger. It was basically in California, the plaintiff sued to overturn Prop 8, which had banned gay marriage. California did not defend the lawsuit, so someone tried to intervene, either Hollingsworth or Perry, and that went up to the Supreme Court, and the Supreme Court said, yeah, you don't have the right to intervene in this case. Well, in this case, the condo association, the Strata Corporation, actually would have every interest in intervening if this isn't dismissed, because, well, number one, they're the proper defendant, so they should be the ones defending it. But number two, they're the ones that built the wall, so they're the ones that want the wall there, so they're the ones who should be defending to keep the wall there. Do you follow? So, part 4, material to be relied on. Affidavit of Colleen McClellan, sworn October 23rd, 2023. The Strata Property Act, sections 171 and 172. The applicant estimates the application will take 20 minutes. This matter is within the jurisdiction of the master. To the persons receiving this notice of application, if you wish to respond to this notice of application, you must, within 5 business days after service of this notice of application, or if this application is brought under Rule 9-7, within 8 business days after service of this notice of application, file an application response in Form 33. Except Naomi R. Bobby, woman, has stated the rules. She doesn't use forms of the court. because we're in her court, the Naomi R. Bobby court. She sets the rules. File the original of every affidavit and of every other document that, 1, you intend to refer to at the hearing of this application, and 2, has not already been filed in the proceeding, and serve on the applicant 2 copies of the following, and on every other party of record 1 copy of the following. 1, a copy of the filed application response. 2, a copy of each of the filed affidavits and other documents that you intend to refer to at the hearing of this application and that has not already been served on that person. And 3, if this application is brought under Rule 9-7, any notice that you are required to give under Rule 9-7-9. Date 24th of October 2023 by Colleen McClelland, the woman. Once again, I don't know if she put that because she thought it was some legal requirement based on the Sovcit pseudo-legal nonsense, or if the court put it on, or, to keep the caption aligned, whatever. Although, even then, it wouldn't need to be here because this isn't the caption. This is just her signature. So this is now the response to the civil claim. So this is from the defendant, from Colleen McClelland. So remember, this that we just went through was the motion to strike. This is the response to the civil claim. So basically the answer, or it's styled as an answer, so I'm not going to say it's a motion to dismiss 12b6 motion. It's styled as an answer. So between the woman, Naomi R. Bobby, and the woman, Colleen McClelland, response to civil claim filed by the defendant, response to notice of civil claim facts. So basically, she does not admit to any of the facts in paragraph 1. The facts alleged in paragraphs 1, 2, 3, 4, 5, 6, 7 of part 1 of the notice of civil claim are denied. The facts alleged in paragraphs part 1 of notice of civil claim are outside of the knowledge of the defendants. So basically, this looks like it's just a form. So normally in the US, I'd go, as to paragraph 1, this is denied. As to paragraph 2, this is denied. As to paragraph 3, I admit in part, deny the rest in part. It looks like here, it's just none are admitted. It's put in groups. None are admitted, all are denied, none are outside the defendant's knowledge. Division 2, defendant's version of facts. 1, the notice of civil claim discloses no reasonable claim. 2, the notice of civil claim is unnecessary, scandalous, frivolous, and vexatious. And 3, the notice of civil claim is an abuse of process. So the defendant's version of facts, this reads basically as affirmative defenses. Division 3, additional facts. Part 2, response to relief sought. The defendant consents to the granting of relief sought in none of the paragraphs of Part 2 of the Notice of Civil Claim. The defendant opposes granting the relief sought in all 3 of the paragraphs of Part 2 of the Notice of Civil Claim, and the defendant takes no position on none of the paragraphs. Part 3, legal basis. Rule 9-5, striking pleadings. We looked at that on the last page, the previous document. The Strata Property Act, Section 171, we looked at that earlier. we looked at 3, 4, and 5, the case law that was cited in the previous document, as well as that. So, okay. So, finally, at least as far as the court filings, before we get into a little discussion about legal concepts, we have Form 33, Rule 8-1, in the Supreme Court of British Columbia on November 7th, 2023, between the woman, Naomi Arbabi, and the woman, Colleen McClelland, application response. So this is the sovereign citizen lawyer plaintiff's response to the notice of application, basically the application to strike the complaint, the claim. So in familiar terms that we all know from the U.S. litigation we have discussed here, we have had a complaint, and then we did a motion to strike, and then an answer, and now this is the response to the motion to strike. Follow? Good. Application response of the woman, Naomi Arbabi, parentheses, the application respondents. This is a response to the notice of application of the woman, Colleen McClelland, filed October 24th, 2023. Part 1. Orders consented to. The application respondent consents to the granting of the orders set out in the following paragraphs of Part 1 of the Notice of Application on the following terms. None. So this is a response to a motion, but it, at least here, reads like an answer to a complaint, which we wouldn't do that here in the US. I don't know if this is standard in Canada or weird procedurally. Either way, to me, it's weird procedurally, but that's fine. Orders opposed, Part 2. The application respondents opposed the granting of the orders set out in paragraphs 1, 2, 3, and 4 of Part 1 of the Notice of Application. Orders on which no position is taken. The application respondent takes no position on the granting of the orders set out in paragraphs not applicable of Part 1 of the Notice of Application. I, a woman, Naomi Arbabi, hereby confirm, I state on April 25th, 2021, for the first time, I did view the property located in Vancouver with the intention to acquire this property as the home of I. I state at the time I did view the property, and for more than 2 years after I did eventually acquire the property, a low height, clear glass divider, which did look to be installed professionally and permanently as it was screwed to the wall and or floor of the deck, was installed where the woman, Colleen McClelland, did later cause to be installed on September 5th, 2023, a 66.5-inch tall opaque glass and steel frame divider. I state before making the offer to acquire this property, I did review documents relating to this property in order to find out about any potential problems that this property may have. I state among the documents I did review were the minutes of Strata Council meetings for the 24 months prior to the offer of I, and a Strata Form B, which was signed on April 21st, 2023, by the man, John Aveline, who at times acts as the Strata manager. I state the minutes of the Strata Council meetings did not reveal any outstanding problems with the dividers between units that do share the rooftop deck. I state the only reference made in the minutes of Strata meeting to the dividers on the rooftop deck that I did find was on paragraph 8 of the September 25th, 2019 meeting, which read, "The council is developing standards for deck repairs and maintenance, as well as a policy for the repair and maintenance of deck dividers. Council will talk to each affected individually and work out the most reasonable solution." And paragraph 7 of the December 19th, 2019 meeting, which reached, Strokes Renovations will be providing pricing on deck dividers. Once the plans have been finalized, a meeting will be set up with the third floor owners and the plans will be implemented. Well, if there's someone, if there's talk in that saying that Strokes Renovation will be providing pricing on deck dividers, that's your clue. They're putting in deck dividers. There's talk of deck dividers. Like you can't say that there was nothing in there about deck dividers. They didn't say when or whose or what, but deck dividers. Clearly, if they're getting bids for deck dividers, there's a problem with deck dividers. They either need to be reinstalled, they need to be upgraded, there needs to be something. Clearly, the Strata Council is unhappy with something about deck dividers. But once again, even absent any Strata Council minutes talking about needing to replace deck dividers, needing to put up a wall, a privacy wall, there is nothing that you need to provide something that says this view is a property right. The Strata does not have the right to put up privacy walls. The residents do not have a right to put up privacy walls or to petition the Strata Council to install a privacy wall. That's what you need to provide, but you haven't. So that is the standard. Furthermore, I state the Strata Form B signed on April 21st, 2021 by the man, John Aveline, who at times acts as the Strata manager, did state no to the question that did ask, have any notices or work orders been received by the Strata Corporation that remain outstanding for the Strata lot, the common property, or the common assets? That doesn't mean a work order can't go in the future. Maybe the Strata Council didn't know that this wall was missing. And once they were put on notice after April 21st, 2021, they put in such a work order. It could be that the defendant moved in and realized, hey, this wall doesn't match the others, and put in the request. I say I did reasonably rely on the above documents to conclude that no other man or woman or even legal fiction entity. Artie has entered the chat. Well, he's a corporate fiction, not a legal fiction, so never mind. Go away, Artie. Or even legal fiction entity such as the Strata Corporation has any claim or right to interfere with the state in which I did acquire the property of I, and that if any problem did exist with regards to the rooftop deck and the dividers, that it was resolved at that time, and I did reasonably conclude that the low height clear glass divider was installed at that time. At the time uh, I'm running out of steam here. But at the time I did view the property was the agreed upon solution by all individuals affected, and the plan that was to be implemented by all parties involved. Funny enough, you're not a party to this at all. It doesn't divide your property from the neighbor. And once again, you do not have a property right in a view. There is no vested property right interest. And if you say you reasonably relied on it staying the same, if I moved in, once again, without those pesky trees, I'd have a beautiful view of Mount Olympus that way. If, as some of you may know, my 94-year-old Oma lives next door. My Opa did too until he died 2 years ago. They moved in 1969. Do you know the state of those trees in 1969? They were much smaller. Now, I don't know if they had a view of Mount Olympus at the time, because once again, there could have been other trees that are no longer there. I mean, I know of some massive trees that were right across the street that are gone. We lost 2 massive walnut trees, and between us and my brother, 5 massive pine trees over the last 3 years, because, yeah, it hasn't been kind to trees recently. But let's say my Oma in 1969 moved into her house because she had that beautiful view of Mount Olympus. And she reasonably relied on, no one's going to plant trees to block my view. And if they do plant trees, they're just going to be little titchy things. They're never going to grow 100 feet tall. That's not something you can reasonably rely on. That's not you just can't. It's ridiculous. I do favor the rooftop deck of the property of I over all other areas of the property of I. And as such, on or about February 2023, I did spend about $12,000 on improvements to the rooftop deck in the property of I, which included a new custom designed cedar wood divider between the property of I and another unit, which is adjacent to the property of I. She's got unclean hands. She put up a divider, a cedar wood divider. Cedar wood is famously not transparent. It's opaque. It's dark. She gets to put up a divider. She gets to do it, but others don't. That's unclean hands. If you have unclean hands, you can't sue someone for doing the same damn thing. At least not likely. But let's say the neighbor next door is allergic to cedar. Does he get to sue you? Inquiring minds want to know. Does the Naomi Naomi or Bobby court allow him to sue you if he's allergic to cedar and needs you to take it down? Because he's suffered damages. If the neighbors don't like the looks of the $12,000 of improvements on your rooftop deck, so it reduces their enjoyment of their rooftop decks because they think your improvements are tacky as hell. So they don't spend as much time on their rooftop decks, and so they don't get to enjoy the views of the mountains and the park and the bridges and the sea and whatever else. Do they get to sue you for the loss of enjoyment of their rooftop deck? Because they think your $12,000 of improvements are tacky as hell? Inquiring minds want to know. Is it rules for me or rules for thee, not for me? That's what it looks like here. That's what it looks like here. This bitch made me go through an entire ginger ale. Now I'm down to water. Luckily, Salt Lake has great water out of the mountains. Magna, Westside, not so much, but Wasatch Mountains have amazing water. I state before starting the improvements, I did contact the woman, Jerry Cooper, who at times acts as the president of the Strata Corporation, the woman, Holly Kemp, who at times acts as the member of Strata Council, and the man, John Aveline, who at times acts as the Strata manager, to inquire into any objections there would be to the work I did intend to carry out. I did not receive any objections and was not told anything about any prior agreements about the dividers on the shared rooftop deck, which did or does bind I say from the time I did acquire the property of I until the 66.5-inch tall opaque glass and steel frame divider was installed, I did very much enjoy the view from the property of I, especially during sunsets, when I did meditate on the rooftop deck looking into the horizon at the ocean, Stanley Park, the mountains, and the beautiful heritage Burrard Bridge, watching the last of the bumblebees leave for the day, the lavender garden bed, which I did build as part of the improvements to the rooftop deck of the property of I for the enjoyment of I and the neighbors of I and the enjoyment and growth of the bees in the neighborhood of I. And like, yeah, the sunset is wonderful. My grandparents, not my Oma next door, my mom's parents, they lived in Centerville, Utah, in Davis County. I mentioned it when the Chase Allen shooting. You from that post office that was in Farmington, Centerville is the next city to the south. You drive down that road about 3 miles and then turn up the hill 2 blocks, 3 blocks. You're at my grandparents' house. They bought that house. They're literally one street. There's one more street to the east up before it's just mountain. Their front door was on the east side of the property. 1-story house with a basement. You walk in the front door, you go up 3 steps from the front yard to the front porch in the front door. And then, like I said, there's a basement. The back door, out of the basement, you walk down 2 steps to get to the backyard. That's the kind of slope. And then the roof of the neighbor's house to the west of them was about at the level of my grandparents' backyard. So steep hill. My grandparents bought the house specifically for the sunsets, which for them was over Farmington Bay, which is mostly dry at the moment because of the drought, and Antelope Island. Magnificent sunsets. If their neighbor built a 10-story building blocking their view of the sunsets, my grandparents would have been absolutely fuming. But they would have had a cause of action because Centerville in the single family zoning wouldn't have allowed that. So my grandparents could have forced them to take it down because the city would never have granted the permit. So, but either way, while I empathize, yeah, sunsets are magnificent, but you don't have a property interest in it. I say on or about June 4th, 2023, I did hear angry shouts coming from the rooftop of the property of I, and when I did inspect the source, I did see the woman, Colleen McClelland, and her then partner, the man, Dave, take down the low height clear glass divider without the consent of the man and the woman, whose property is adjacent to the property of the woman, Colleen McClelland, and in the process knocked down other property of the neighboring man and woman. But that doesn't matter to you. That's not a trespass on you. I say sometime during July of 2023, I did become aware of the intention of the woman, Colleen McClelland, to install a 66.5-inch tall divider on the rooftop deck at the border of her unit and the neighbor's unit in between, which I did determine will significantly block the view from the property of I state on July 23rd, 2023, I did knock on the door of the unit, which is the property of the woman, Colleen McClelland, which I did believe at the time to also be where she does live, with the intention to have a friendly discussion with her about the impact of the divider on the enjoyment and value of the property of I state the man, Dave, who at the time did live in the property of the woman, Colleen McClelland, did tell me that he does not have the authority to make decisions on the matter, and that the woman, Colleen McClelland, is not available to talk to I say, while I did chat with the man, Dave, I did hear on his phone, which was on speaker, the sound of a woman whom I did believe to be the woman, Colleen McClelland, ordering the man, Dave, to end the conversation right now, multiple times, in a tone I did determine not to be friendly. So apparently, not only is Naomi or Bobby court, she's also the tone police. I state on the same day as I did not believe I will be able to talk to the woman, Colleen McClelland, in person. I did write a correspondence to her, which was hand delivered to her then partner, the man, Dave, in which I did ask her to reconsider her plans, as it would cause I loss, and I did show the intention of I to reach a balanced solution to address the concerns from both sides. Part 4, factual basis. I say I did not hear back from the woman, Colleen McClelland, because she doesn't have to respond to you. I state on September 5th, 2023, the woman, Colleen McClelland, did cause a 66.5-inch tall opaque glass divider to be installed on the part of the rooftop deck that is her property, which did cause significant loss to the enjoyment and value of the property of I. Well, that's the key right there. She she caused to be installed on the rooftop deck. That is her property. It's her property, not your property. She didn't trespass on you. It's on her property. What she does on her property, as long as it's not against the law, isn't a trespass on your property. It is not anything. It's not anything. It sucks for you, but it's not her problem. I really need to hurry this up because my voice isn't going to last. I state I, of course, the sass in my voice doesn't help, did not have any further communication with the woman, Colleen McClelland, until after the divider was installed, at which time I did serve her 4 lawful notices by way of personal delivery and or Canada Post, and a subsequent notice of claim of I, the service for which she did evade on October 11th, 2023. I state I did press claim in a court in law on October 5th, 2023. I say herein and verify in open court all to be true. Or all be true, sorry. Legal basis / handwritten lawful basis. Because sovereign citizens believe there's a difference between legal and lawful. So long as the claim of I is not unintelligible, confusing, and difficult to understand, the style, syntax, or manner in which the claim of I is pressed does not have any bearing on its merits, and it cannot be the basis for determining that a claim is untrue. The manner in which this claim is brought forward is not due to any animosity towards the legal system or to circumvent a legal channel that may exist for resolving this dispute. Law is not static, and even if novel, it may still successfully be upheld in a fair court. I simply wish to press this claim in the private as a woman, as I believe this will achieve a fairer outcome whereby no man or woman who at times acts as an owner of the strata lot, who may not even know a rooftop deck does exist, let alone about this matter, is obligated to make financial contribution towards the claim of I for loss of enjoyment of property, the responsibility for which may in fact lie with the woman, Colleen McClelland. So, what she's saying here is even though the strata law requires me to sue the strata if I believe I have been wronged, if I need something fixed, if something need a change needs to be made, even though the law says that is who my cause of action is against. I don't want to inconvenience the other members of the strata association. So I can circumvent that law and sue her, the defendant, directly. It doesn't matter that Canada or British Columbia or Vancouver has passed laws on who I have to sue in this situation. I, Naomi or Bobby, court, get to decide who is responsible, who I get to sue, who I have a cause of action against, even if it's contrary to the law that has been duly enacted by the government. Because I, Naomi or Bobby, court, am the main character. You're all in my world. You all get to play by my rules. Right? This is not a claim with regards to the strata lot title in the land title registry that corresponds with the apartment located in Vancouver, BC. Rather, this is a claim regarding the property of I, being that which is proper to I, to the exclusion of others in society. Well, that's kind of the right statement of what property law is, or property is. It's something that you have the right to, and to the exclusion of all others. But once again, the view isn't your property right. I mean, if you want the view, get a ladder. Get a ladder. Climb. That's how you can regain your view without interfering with others' property rights. That's how it works. I, a woman, have dominion over the property of I to the extent that I do not cause harm to others unless I voluntarily enter into a contract and give authority to another to administer the property of I. So she thinks that the defendant has to enter into a contract with her in order to build a wall. Once again, this is nuts. Now, I mentioned we have that nice fence on the back of the property. I don't actually know if it's on the property line, a little over onto the neighbor's property line, a little over onto our property line. It doesn't matter. It's been there for 40 plus years. Now, when there was a fence between this house and my brother's house, the fence was encroached a little onto this side of the property line. I do know that. But now, let's say, or no, scratch that. I have a real life example. My Oma. Like I said, she lives next door. Now, the neighbor to the back of her is not the same neighbor as at the back of me, because her yard doesn't go as deep. There is another neighbor around the corner who abuts against hers. Now, that neighbor's garage is basically used as the fence for half of my Oma's yard. And then there's a grape stake picket fence for the other half. That's what serves as the back fence of my Oma's property. Now, that garage is not built exactly on the property line. That would be illegal. There has to be a buffer. That fence is not exactly on the property line. It is on my Oma's side of the property line. So, in theory, for half of it, a little of my Oma's property is on the neighbor's side of the divider, and a little of the property is on my Oma's. A little of the neighbor's property is on my Oma's side. Understand? Now, about 10 years ago, my brother rebuilt this fence because the posts had rotted out. And he, out of convenience, put the pickets on my Oma's side because, he's working on her side. The neighbor was apoplectic. He thought it was ugly having the pickets on my Oma's side, and he had to see the posts and the cross beams. Now, it was built on my Oma's side of the property. It's her fence. He had no say. Now, what he could have done, he could have built his own fence on 6 inches onto his property line. He could have asked my Oma, can I put pickets on my side so that I have the view that I want? But once again, it's my Oma's property. She doesn't have to do it. They could have, like this Looney Tune thinks, there's no contract, so they can't have built this. They didn't have a contract with me. Now, my Oma could have had a contract with the neighbor saying, we agree to rebuild this fence exactly on the property line, and I will pay half, and you will pay half, and we're contractually bound to this, and blah, blah, blah. But they didn't have to. Instead, my Oma built her fence on her property line, and that's that. Now, the neighbor did apologize to my brother for being apoplectic at him, so that's fine. I claim the apartment located in Vancouver and the aesthetic appeals in which state I did acquire the property as the property of I. You can claim it as your property all you want. It's not your property. That's the thing. You don't get to make something your property. You don't get to claim a view as your property and enforce that on others. I believe blocking the view from the property of I without the consent of I in a manner as does the divider in dispute, which does cause I significant loss of value and enjoyment of property, is administrating the property of I without consent. Therefore, to do so is to enter the dominion of I without authority. So let's say her property isn't the first row on the harbor. What happens? Vancouver is a constantly growing city. They're putting in condo towers all the time. Let's say they put a tower next door on the adjacent property. So not even the same strata corporation. On the next property, they put up a new 1,000-foot tower. Completely blocks her view. And it's legally built. The city of Vancouver grants all the permits. It's legally built. Have they trespassed on her? Did they steal her property right in the view? No. Now, of course, most cities, in granting permits to build a tower, there are considerations for view and light and whatever. So like downtown Salt Lake, if you're going to build a tower, you're limited. You number one, you can't build it as high as you want. You've got to ask the city for permission. But number two, you have to have, generally it's going to be required to be stepped or offset so that if the property next door wants to build a tower, at some point it's not just a solid wall. So that there's limits, but at the same time, if they block the specific view that you want, tough beans. The trespass is to the dominion of I, akin to other forms of trespass, such as trespass to the person or trespass to chattel and land. So she's just making up a whole new tort. Remember, toward the beginning of the video, I discussed the three types of trespass at common law. There's trespass to the person, there's trespass to property, and trespass to chattel. She's claiming trespass to dominion, which is akin to the three common law forms of trespass. So she's inventing her own form of trespass, trespass to the dominion. That does not exist. You're making shit up. You're smoking the wacky tobacco. You're nuts. This is pseudo legal Borogrove babble. It's Jabberwocky. Judge Middleton has it right. The trespass by way of loss did occur when by causing the divider to be installed, the woman, Colleen McClelland, entered the dominion of I without authority, whereby she did cause I loss, and did not leave the dominion of I when noticed of this unauthorized intrusion 3 times by way of written lawful notices. Now, wouldn't your eyes looking onto her dominion be trespass to her dominion? She has the right to privacy within her dominion. So even by your made up laws, you looking in on her causes her harm. It's trespass to her dominion. Therefore, she has the right to build the wall. Works both ways, doesn't it? No, no, it's just the court of Naomi or Bobby. The claim of harassment the woman, Colleen McClelland, does make against I in her correspondence dated September 11th, 2023, is based on hearsay evidence, most of which is untrue. Even if this was a legal complaint made by the legal fiction dead entity Naomi or Bobby in all caps, the registered owner of the title to the strata lot based on legal acts, codes, or statutes, the legal fiction that is the strata council, all caps, still did not and does not have the legal authority to unilaterally administer such a significant alteration to the strata lot, which did cause significant loss of enjoyment and value. One, as it is bound by the representations it did make in the documents, such as the strata form B and minutes of the strata council meetings. Two, as it did not similarly enforce other alterations made to the original dividers on the same rooftop deck within the span of at least 10 years. And three, as it has a duty to enforce strata bylaws which prohibit an owner to use a strata lot, the common property, or common assets in a way that unreasonably interferes with the rights of other persons to use and enjoy the common property, common assets, or another strata lot. Regardless, this claim is not for enforcement of any bylaws that may be the legal duty of the legal fiction strata council. Rather, it is for the loss of enjoyment and value of property caused by an unlawful trespass. That the legal fiction, that is, the strata council, did fail or did refuse to fulfill its legal obligations under the Strata Property Act, and thereby did not accordingly enforce the bylaws on the offending owner, Colleen McClelland, all caps again, does not eliminate the responsibility of the woman, Colleen McClelland, to provide remedy for trespass against I by way of loss. When a man or woman acting as a member of the Strata Council does something outside of the authority granted by the Strata Property Act, he or she does so in his or her private capacity. Therefore, any man or woman who at times acts as a member of the Strata Council who did assist the woman, Colleen McClelland, in installing the divider did so in his or her private capacity, notwithstanding whether or not he or she did so under the guise of the legal fiction that is the Strata Corporation, all caps. A legal action did start against the legal fiction that is the Strata Corporation by the owners of the 3 affected strata lots, including Naomi or Bobby. And before the initial stage, which is a hearing with the Strata Council, despite the alleged earlier legal advice received by the Strata Council, the legal counsel for the Strata Corporation did represent on behalf of the Strata Council its agreement to enforce an alternative divider which does not block the view from the affected strata lots. I am not aware of any man or woman acting as a member of the Strata Council or otherwise having the authority from I to administer the property of I and to diminish the value of the property of I and cause I loss of enjoyment of the property of I by installing the 66.5-inch tall opaque glass divider, which did block the view from the property of I. Materials to be relied on. Affidavit of Greg Temmerman, made October 27th, 2023. Affidavit number 1 of the woman, Naomi R. Bobby, affirmed, not made, but affirmed, November 6th, 2023. And affidavit number 2 of the woman, Naomi R. Bobby, affirmed, November 6th, 2023. The application respondent estimates that the application will take 50 minutes. The application respondent has not filed in this proceeding a document that contains an address for service. The application respondent's address for service is, we don't care. Date 6th of November 2023, signed Naomi or Bobby, a woman. Somehow I don't think her genitals or pronouns or anything actually matter in deciding this case. So it doesn't, putting a woman doesn't matter in the slightest. So that's the materials we have in the case. That being said, I mentioned we're going to discuss a few legal concepts. So, good old Wikipedia. What we have here is a discussion of spite fences or spite walls. So, just reading the top description, in property law, a spite fence is an overly tall fence or a row of trees, bushes, or hedges constructed or planted between adjacent lots by a property owner with no legitimate purpose, who is annoyed with or wishes to annoy a neighbor, or who wishes to completely obstruct the view between lots. Several U.S. states and local governments have regulations to prohibit spite fences or related regulations, such as those establishing a maximum allowed height of fences. In the United Kingdom, the terms spite wall or binder wall are more commonly used. So I realize, yeah, I'm using Wikipedia, but yes, this is what we learned in law school. Wikipedia is just a handy source. So Plus, it has pictures. So what you can see here, this is a spite wall in Lancashire in northwest England. So we have the house here, and then between the house and the car, there's this wall built. It looks like it's 6 inches away from the house, and it blocks even the second story window. Although it's England, so that would be the first floor, the ground floor, and the first floor. Here in the US, first and second floor. But it blocks that entire side of the house. And what's the purpose? It's to block their view. Now, they may say, it's privacy. We sunbathe nude in our backyard, and this protects our privacy. So, one of the most famous spite walls is from San Francisco. It's so Charles Crocker was a famed railroad investor, just multi-millionaire at the turn of the past century. And he built a house on the appropriately named Knob Hill, because he is quite the knob. And he built a fence surrounding his neighbor's house, Nicholas Young, because the multi-millionaire real estate baron wanted to buy that property. And the neighbor said, no, I like living here. So Crocker said, well, I'm going to make it unpleasant for you to live here. And so he built, let's see, well, the fence was so tall that supporting buttresses had to be used. So I don't know how tall, but so this is Charles Crocker's mansion, back left. Magnificent building. It was knocked down in the earthquake. And then this is General David Colton / Collis Huntington mansion. And then you can see behind it this spite fence, which covered 3 sides of the neighbor's yard. And it's taller than, like, you can see this, the David Colton mansion is two stories high. The spite wall looks to be at least 3 stories high. And in fact, it looks like it's about up to the 3rd floor of the Charles Crocker mansion. Just the attic spaces and parapets are above it. And this covers both the long sides of the yard and the back. So he only has street frontage. So this is an example of a spite wall. A 5.5-foot privacy fence, not in the slightest. And besides, like I said, it's, even if it's tall, is there a legitimate purpose? So like here, we don't have a citation, unfortunately. Do better, Wikipedia. But if the structure is found to have a useful purpose, then it may not be considered a spite fence. In one case, a man built a 13-foot fence on his property and his neighbor sued him. Now, a 13-foot fence, that's considerably taller than what's generally allowed. Like I said, in my neighborhood, it's either 6 or 8 feet, generally. But so the neighbor sued him. The man put up the fence because the neighbor kept throwing garbage over the old, shorter wood fence. And since keeping garbage out of one's yard is a legitimate reason to have a fence, it was found not to be a spite fence. So, you know, if I own a gravel pit and there's a residential neighborhood next door. Now, that gravel pit might be related to the next thing we're going to discuss, nuisance. Now, in order to contain the dust and the rock chips and debris from crushing gravel, I might have a 30-foot fence to keep my debris in. It's built, it may annoy the neighbors, but it's built for their benefit, or at least to reduce my liability to them. So, scrolling down, this isn't necessarily a spite fence, but it's in the Wikipedia article. We have one in Utah. So in 2008, and I'm going to do another one in Utah at the very end. It's my favorite. In 2008, a farmer in Hooper, Utah, and that is the correct pronunciation for those of you who don't know. It's not Hooper, Utah. It's Hooper, Utah, up near Ogden, Weber County, right against the Great Salt Lake. Placed 3 old cars upright in the ground after a dispute with his neighbors, who objected to the flies, mosquitoes, and dust from his farm, yet also rejected his proposal to build a fence between their property and his farm. The farmer described the construction as Redneck Stonehenge. And here we have a picture of Redneck Stonehenge in Hooper, Utah. And yeah, I don't know that I'd mourn either of those 3 cars. Either way. So then we have nuisance. So this is a common law tort based on the English common law. Utah actually has nuisance in it's codified, so it's not just common law here. But so under the common law, persons in possession of real property are entitled to the quiet enjoyment of their lands. However, this doesn't include visitors or those who aren't considered to have an interest in the land. If a neighbor interferes with that quiet enjoyment, either by creating smells, sounds, pollution, or any other hazard that extends past the boundaries of the property, the affected party may make a claim in nuisance. So you may say, this 5.5-foot fence is a nuisance because it interferes with Naomi or Bobby court. It interferes with her quiet enjoyment of her property, which includes the view. Well, they're not creating a smell, and smells, it's not all smells. If I'm barbecuing beef and you're a vegan, that's not going to qualify. It's noxious smells. Sometimes cigarette smoke can. That's codified here in Utah, at least for like condos. If I put a slaughterhouse next door and the processing of pigs is real smelly, that would be a nuisance. That said, rock plant, nuisance. But do you know what? Usually when people sue a gravel pit for nuisance, the gravel pit was there first. And suburban sprawl brought residential land next to the gravel pit, and then the new residential owners sue the gravel pit and say, it's a nuisance. I shouldn't have to live next to that. But they were there first. You came to them. It's like here in the Salt Lake area, right on the county line between Salt Lake County and Davis County to the north, there are a number of refineries, oil refineries. And people have built right up to them. And now those stinky refineries, they're a danger to me living next to them. They should go away. Now, I agree that the refineries shouldn't be there because we have a real pollution problem in the Salt Lake Valley because we're surrounded by mountains, so pollution can't escape very well. So in the winter, we have inversions which trap the pollution in, and you can practically chew the air some days. So it's not a good location for an oil refinery to begin with. But the people who move next door to an oil refinery and then say, you need to make that oil refinery move because if it explodes, it's a danger to me, when it was there first. They can't claim nuisance. So legally, going back to Wikipedia, the term nuisance is traditionally used in 3 ways: to describe an activity or condition that is harmful or annoying to others, e.g., indecent conduct, a rubbish heap, or a smoking chimney. So, indecent conduct, having a brothel next door, that could be a nuisance. Like, that's one of the things codified in the Utah nuisance statute. 2, to describe the harm caused by the before mentioned activity or condition, e.g., loud noises or objectionable odors. Or 3, to describe a legal liability that arises from the combination of the two. However, the interference was not the result of the neighbor stealing land or trespassing on the land. Instead, it arose from activities taking place on another person's land that affected the enjoyment of that land. So that caveat is saying, look, it's nuisance. If it encroached on your land, it would be trespass. If they were doing something on your land, the appropriate tort would be trespass, not nuisance. Now, people building a 30-foot wall, even if it's legitimate, people have sued for nuisance over that, saying, I have a right to light. Not necessarily, but you might. You might. But a view, no, unless it's in the deed, unless there's something like an actual vested property right. So, and then I was going to discuss trespass to land, but we don't have to because apparently this was trespass to dominion, a completely made up tort. So we're not even going to discuss trespass to land, but I mentioned my favorite nuisance This is in Riverton, Utah, or well, it was in Riverton, Utah. I've mentioned Mount Olympus many times. This is not Mount Olympus. Mount Olympus is the next mountain to the left off screen. You go up this canyon, basically aligned with the pinky. That leads you to Snowbird and Alta. That's Little Cottonwood Canyon right there. So these neighbors in Riverton, Utah got into a feud. I can't remember exactly what it was about. It was about construction. I can't remember if it was construction of this house or the neighbor's house. Either way, in order to tell the neighbor to fuck off, this guy put an attic vent that the neighbor said, he's flipping us the bird on his house. And that's a nuisance. That makes it so we can't enjoy our yard because every time we go out in the backyard, we see that. And that is telling us to fuck off every time we go in our backyard. And this neighbor who put it on his house, he said, hey, that's a cactus. That's a saguaro cactus. What's wrong with that? Now, eventually he made nice and took it down. So it never was litigated, but that's not a nuisance. That, frankly, that's unless there's a building ordinance, and I mean Riverton, there's ordinances for everything building. It's such a boring. The south end of the valley is so boring. All the colors are beige and tan because those cities don't like any character and require houses to be beige and tan and brown and awful. So they might actually have an ordinance in their building code saying all attic vents must be square or oval in this size and blah, blah, blah. But I'd argue, hey, it's my First Amendment. I get to express myself on my house. This is akin to a sign. It's, besides which, it is a cactus. I can put a cactus, whatever. But, and hey, another nuisance. One last example. So, 20 years ago, I mentioned that back fence, the decorative fence. 20 years ago, that wasn't our back fence. It belonged to the neighbor around the corner whose house abuts my Oma's. The one whose my house my brother built that fence. Well, a previous owner of that house was an older couple, and their ne'er-do-well son moved in. He was in his 50s, and he was a criminal, and he was awful, and he was a rabbit breeder. And so he bred hundreds of rabbits in that backyard, and never once cleaned up after them. And the smell was awful. We couldn't use our backyard. My Oma couldn't use her backyard. She couldn't even open her windows because at some point he put lots of the rabbits in that garage and put one of the turbine vents on the roof on the slope towards my Oma's yard. So if she tried opening her windows, and she doesn't have air conditioning, so she has to open her windows in the summer, the smell would go right into her kitchen. That's a nuisance. Now, we tried to work with animal control. They had no real problem or no real power. The health department did, but they didn't do anything. Neither did our old city councilman. Dave Bueller, you suck. So what we could have done is we could have sued for nuisance. And actually, we probably could have got a court order to remove the rabbits because this is a residential neighborhood. It's not a, we're in the city where it's not agricultural. There's a limit. He had more dogs than he was allowed also. So what was our eventual solution? Well, the guy's parents both died. They were old. His wife died, cancer. And so we get a knock on the door one day, and a guy comes and says, "Can I peek over the back fence?" And, yeah. So he does, and he's like, "Do you like these trees?" Yeah, because I'm gonna buy that house and I'm going to put condos all the way back. Unfortunately, those are the same walnut trees we lost over the last 2 years, and one of the pine trees. So walk around the corner, knock on the door, and don't like the guy, but knock on the door and say, "So you're selling, eh? We'll buy it." Set a price, agree right then and there. It was a good price, but the home was a dump because he was awful and never cleaned. And like, I have never been as disgusted as cleaning out that garage. To deal with the dog shit because, like I said, he never once cleaned up after any of the animals, and he had more dogs than he was allowed. We dug a hole like 4 feet deep and 2 feet across, and we just raked the crap into it. And for like 10 years, we had to keep topping it up with dirt as it compacted. And then the rabbit stuff, great fertilizer. We had great gardens for a long time from it. But like, so if we had sued him, we probably wouldn't have been able to buy it. But at the same time, we could have, because that is a textbook example of a nuisance. And then what we did is we fixed it up, put a fence across, took what was behind us, including a little behind my Oma, and then sold the house, but kept the yard. We subdivided. So yeah. But that's a good example of a nuisance. So I think that's about where to leave it. Besides which, I'm exhausted. So thank you for joining me. I hope you enjoyed it. I hope you learned a little bit at the end too. And so please, on your way out, like, share, subscribe, do all that fun stuff, and go do the same. Remember, huge thanks to Ian Runkle for sending me this. So subscribe and do all the YouTube-y stuff for Runkle of the Bailey as well. And I will see you soon. Bye-bye.